A warm good evening to all of you. On behalf of the Mediation Society, I warmly welcome you to the second part of the two-part series of our mediation conversations. The topic for today's discussion, mediation advocacy, rethinking the lawyer's role in mediation. I am Advocate Amina Rafiq, and it is my privilege to chair this evening's discussion. In our first session, we explored why every lawyer should learn mediation. Today's conversation takes that discussion a step further. We ask a more practical question: what is the lawyer's role in mediation? With that, let us begin. Introducing the lead speaker for the day, it is my privilege to welcome Advocate Rajesh C. Muttat. Rajesh is the president of the Mediation Society and, as he prefers to be introduced, a mediation activist. Through his work, he has consistently championed mediation as a culture of dialogue and has encouraged lawyers to embrace mediation as an essential part of modern legal practice. Welcome, Advocate Rajesh. To our speakers, Advocate Simi V. Taragan. Simi has over 5 years of practice before the District Court Thiruvananthapuram and the High Court of Kerala. An APCAM certified mediator, she combines litigation experience with mediation practice, particularly in family, matrimonial, commercial, and corporate disputes, bringing a balanced and practical perspective to dispute resolution. Welcome, Simi. Advocate Ruben George Roque. Ruben has over a decade's experience before the High Court of Kerala and the courts in Ernakulam. He has represented parties in numerous court-referred mediations involving property, commercial, matrimonial, and other civil disputes, giving them valuable insight into the lawyer's role inside the mediation room. Welcome, Ruben. Our next speaker, Advocate Anirudh Kumar. Anirudh practices before the original side of the Madras High Court and the civil and commercial courts in Chennai. He holds an LLM in international trade law from NUALS. A strong advocate for consensual dispute resolution, he believes that structured dialogue offers the most effective way to resolve private disputes. Welcome, Anirudh. Our final speaker, Ms. Fatima Naurin. Fatima is a fourth-year BBLLB honors student at Bharatamada School of Legal Studies and a company secretary student. She is one amongst our youngest alumni and has recently won first place in the All India Moot Court competition conducted by the ICSI Kochi chapter, and she serves in the Knowledge and Communication Division of the Mediation Society. Welcome, Fatima. Before we start, just a small message. We are committed to making people aware of mediation and organizing more programs like these. To stay updated about our programs, you can join our WhatsApp community through the link that is displayed in the chat box. We invite you to share your thoughts in the chat box. Now the floor is open to the speakers. Over to the speakers.
Thank you, Amina. Mediation advocacy, the lawyer's role in mediation. In the last session, which is the preceding session in this two-part series, we talked about why every lawyer should learn mediation. And we argued that every lawyer should learn mediation for several reasons. One of those reasons is to take up a specialized job, which will progress their career. And one of those specialized jobs, the other one being a mediator, the second one is mediation advocacy. That is the role of a practicing lawyer in mediation. Today, we will examine that particular aspect of mediation. Now, if you look back over the last 20 years or so, the 20 years coming from 2004-05, where mediation actually started in India at a formal level, I think it was in Chennai. It started in 2005, and perhaps in Gujarat in 2004. Mediation in India has come a very long way. It has moved from the fringes where some people barely talked about it to something that is now very much part of the mainstream conversation on dispute resolution. It has come really a long way. You will see that today there are court annex mediation centers everywhere. Courts regularly encourage parties to at least explore consensual settlement even before or even pending litigation. We have many more mediation institutions than we used to. Training opportunities have multiplied. Of course, we now have the Mediation Act 2023. So if you look at all of that, you could quite confidently say that mediation has arrived. But has it? How do you actually gauge the emergence and the arrival and development of mediation? I believe the real gauge of whether mediation has arrived should be the extent to which lawyers have integrated it into their legal practice on a daily basis. The fact that, or the gauge that the lawyers have integrated mediation into their everyday legal practice is probably the real one when we try to understand whether mediation has become popular in India. So the question is really, despite all the institutional developments which has happened, has mediation become the bread and butter, or if you like, puri masala or idli sambar of our legal practice? That's the real question. Now, why is lawyer participation so important? That's because lawyers occupy a very unique position within our legal system, in our dispute resolution system. For most parties, lawyers are the first point of contact. They're the gatekeepers. Clients rarely decide for themselves how a dispute should be managed or which process they should be selecting to resolve their dispute. So typically what they do is they go to the lawyer and seek their legal advice. It is the lawyers who explain the available options, recommend the most appropriate process, prepare their clients, and guide them through it. That is why they are extremely important. And also, as with every other dispute resolution process, lawyers heavily influence whether clients would meaningfully attempt or even seriously consider mediation. And in fact, the lawyers' influence extend even beyond the individual clients. They constitute, we all know that lawyer community constitute the largest professional constituency within the justice system, which means no dispute resolution process can realize its full potential without their confidence and active participation. So that is the answer why lawyer participation is the real gauge of popularity of mediation. And to be fair to the lawyers, they had some resistance. There was some resistance going on in the initial stages of mediation, but they have come a long way too. They have accepted mediation. The initial resistance to court annex mediation system have gone. Lawyers appear in court annex mediation system on a daily basis. They also train themselves and practice as mediators. Professional associations like lawyer association, bar associations actively support mediation training and campaigns. Yet, if you look around, I don't think mediation has still become an indispensable part of most lawyers' day-to-day professional toolkit. Not yet the idli sambar. And I dare say that the lawyers have not embraced mediation to the extent one might expect. After all these 20 years of sustained judicial encouragement, institutional development, and legislative recognition. Why? Many possible reasons. Several. Could be the deeply rooted adversarial culture of legal practice, where we like to fight rather than collaborate. We like to compete rather than compromise. Maybe the economic concerns, at least in the short term, that mediation may not yield that much money. Misconception about mediation, uncertainty about the lawyer's role, and to a great extent, limited attention mediation receives from legal education. Until very recently, there was no mediation in our LLB curriculum. All of these explanations have some force for sure, but I think all of these are symptoms to a deeper problem. I think the issue is a conceptual deficit in our understanding of mediation. Or simply put, we just don't understand mediation sufficiently enough. And so what is the issue with understanding mediation? If you look at much of the last 2 or 3 decades, or perhaps the last 2 decades mainly, our focus has been on mediators, their training, their appointment, their conduct of mediations, with far less attention paid to mediation itself as a distinct model of dispute resolution, and more importantly, to where lawyers would fit in that model. This reflects two assumptions which I am arguing is wrong about mediation. First, we tend to identify mediation with the mediator rather than with the negotiation between the parties. We see mediation is mediator's game, where mediator is the king, parties are sidekicks, and even some of us think that mediation comes from mediator. It could be true from a English literature point of view, but the point is this assumption of putting mediator in the center and perhaps the only main role overlooks the fact that at its core, mediation is facilitated negotiation. The mediator facilitates the negotiation process while the parties, often assisted by their lawyers, remain responsible for negotiation. Lawyers advise and represent the parties throughout that negotiation. We overlook that most of the time. Second, we also tend to identify mediation with mediation session. What happens once the mediator and the parties enter into the mediation room, rather than with the broader dispute resolution process, which that session is only one part. Our tendency to think that way, that mediation is limited to mediation session, perhaps is a contribution, unintended perhaps, by the court annex mediation culture, where mediation is typically encountered after litigation has begun, almost as if it were simply another stage in the process. Mediation, however, is much more than a mediation session. It is a dispute resolution process that begins long before the parties sit down to negotiate and often continues long after the mediation session has ended. It is not a one-off event. It is a long process from the selection of mediation as a dispute resolution process to probably the compliance with the terms of the settlement agreement, if there is one. If mediation is understood this way, as facilitated negotiation rather than a process defined primarily by a mediator and as a distinct dispute resolution process rather than merely a mediation session, then the place of mediation advocacy will begin to emerge most naturally. And let me share a slide with you so that you can see the bigger picture as I talk on mediation advocacy. What exactly is mediation advocacy? I hope you can see that, right? Full screen?
Yes.
Okay. Now, mediation starts with perhaps the most critical question of all. Is mediation the right process for this dispute? Lawyers have traditionally advised clients on rights and remedies. Increasingly, however, they are expected to advise clients on how to find the best solution for their dispute. The first step, of course, is to choose the dispute resolution process. That advice, of course, calls for a broader perspective than simply assessing the legal merits of the case. So suitability assessment is the first step. Is mediation the most appropriate process? When you do that, a lawyer must consider whether the dispute is amenable to mediation, whether the law allows certain disputes to be mediated, there is a bigger question of mediatability, which we will deal with in some other session. But the lawyer must consider at this stage whether the dispute is mediatable, whether the parties are genuinely willing to participate, whether the dispute has matured sufficiently for meaningful negotiations, what the clients hope for, and whether mediation is likely to better serve those objectives than litigation or arbitration. Otherwise, why would somebody wants to go for mediation? The lawyer must also consider the nature of the parties. Some parties are ready to engage in constructive dialogue. It comes naturally to them, while others remain firmly anchored in a competitive mindset. They are hardwired to fight. Just different nature. So choosing the appropriate dispute resolution process is itself a very important act of advocacy. Now, once that decision has been made, the lawyer turns his attention to preparation. That's the stage number 2. Clients need to understand what mediation realistically can achieve, how the process is likely to unfold, what decisions they may have to make along the way. They need to think through what are their objectives, how do they evaluate their alternatives if settlement is not reached, say their plan B, identify acceptable outcomes, and agree in advance on the point beyond which settlement would no longer serve their interests. That's the reservation point, if you want to know the technical term for that. In the third step, before the mediation begins, lawyers have an important role in designing the legal framework within which it will take place. They do so by drafting appropriate mediation agreements. It could be a mediation clause or a MEDAB clause where mediation and arbitration clauses are involved, or it could be a multi-tier dispute resolution clause where more than two disputes are involved in resolving a potential dispute. In doing so, lawyers not only confirm the parties' agreement to mediate, but also determine the process, the procedure which will govern the mediation. Then comes the actual negotiation. This is probably where the mediator takes charge. Again, there is an illusion that once the mediator takes charge of the process, many lawyers assume that their role becomes less significant. But it's quite the opposite. If anything, the lawyer's judgment becomes even more important as negotiation unfolds. Throughout the mediation, lawyers evaluate proposals, test assumptions, assess legal and commercial risks, help lawyers make informed decisions. In many commercial disputes, lawyers even play the leading role in negotiations themselves. So basically, the parties will sit back, the lawyers actually negotiate on their behalf. In some cases, in corporate cases, the clients may not be fully present as well. They may send a junior representative, but the lawyers do the negotiations. There, the focus of advocacy changes. Instead of persuading a judge or arbitrator, the lawyer helps the client make best possible solutions during an ongoing negotiation. The lawyer's role doesn't end once the parties reach an agreement in principle. Reaching an understanding is only part of the task. The lawyer must ensure that the mediated settlement agreement accurately reflects what the parties have agreed and is capable of being implemented and enforced. In fact, a poorly drafted agreement can undo the success of the whole mediation. And even after the agreement has been signed, the lawyer's involvement may continue. Depending upon the applicable legal framework, the lawyers may need to seek interim protection, and that can happen during the mediation process as well, or advise or assist clients in enforcement or challenge proceedings related to mediated settlement agreements. So, taken together, this is mediation advocacy. These functions constitute mediation advocacy, and which is basically encompassing the lawyer's professional contribution throughout the mediation process, from advising on the suitability of mediation to preparing the client to negotiating, drafting settlement, and where necessary, helping out in the implementation and enforcement. So, but you must understand that mediation advocacy is neither a new branch of legal practice, nor an entirely new set of professional skills. You can see that much of mediation advocacy, advising clients, assessing legal risks, negotiating settlements, drafting agreements, protecting legal rights, and even seeking assistance from the court, is already embedded in everyday legal practice. What mediation advocacy brings is the same familiar functions together within the mediation process. I'll show you one more slide. That said, I said that most of it is already part of our legal practice. There is nothing new in it. Most of it are a set of professional skills which we are familiar with. That said, however, mediation calls for two additional competencies. Just two additional competencies. First, of course, is a deeper understanding of mediation itself. Lawyers need to understand not only the mechanics of the process, but also what's the underlying philosophy, the possibilities, and of course, more importantly, the limitations of mediation. Unless mediation is understood as a distinct model of dispute resolution, it is going to be very difficult to advise clients confidently on how and when to use it. So the first additional competency you may require as a lawyer to conduct mediation properly is a deeper understanding of mediation itself. And secondly, it's about negotiation. I will explain that, or I will argue that negotiation lies at the heart of mediation advocacy. But while it lies at the heart of mediation advocacy, we may be familiar with different types of negotiation. Mediation calls for a different way of thinking about negotiation and problem solving. We will come to that. It asks the lawyers to do more than just bargain over the positions which we are so used to. It asks the lawyers to help clients to explore possibilities that may not be visible within the conventional adversarial negotiation. Now, what we were trying to say so far is that mediation advocacy encompasses the whole process of mediation, starting from advising your client as to whether to choose mediation as your dispute resolution process, to helping them settle the matter, and if there is a settlement agreement, help them comply or implement or even execute that mediated settlement agreement. All of these are within the band of mediation advocacy. And for that mediation advocacy, to practice mediation advocacy, we need all the competencies we have as a lawyer, as a legal practitioners, plus two additional competencies. One is the deeper understanding of mediation, and two is another deeper understanding as skill development as a negotiator. I will pause now and call Advocate Simi Varghese to share any experience you may have with the mediation advocacy itself.
Thank you, Rajesh sir. Well, I would just like to quote and unquote, as Rajesh sir told, it is a facilitation that happens in mediation. And all we need to think is that it's not just ending with the mediation sessions there, but how far it is carried out of the mediation room. Now, my experiences, like multiple experiences that I had, one was where the mediator felt that, you know, if the lawyers are there present in the room, it would take into an adversarial situation where, you know, they were bringing the law points, and as Rajesh sir told, they look at us as if we are there to compete with each other, rather like maybe being a certified mediator, I understood, like, you know, we are supporting them, but however, the mediator was not comfortable with us being in the room, and she had almost asked us to leave the room, which was quite awkward for us also, because our clients depend mainly on us, because when the court says that this should be going to mediation, the clients are, you know, in doubt whether this mediation is going to work out or not, if if the mediator is going to be biased, or will they be able to present all their points there? Will the advocate be present in the room? So there are a lot of questions that come up. So that was one experience, whereas another one was like where we had these siblings who were over a property dispute. Now here the mediator was quite, comfortable with having the advocates along, and the mediator did explain to the clients as well what is your advocate's role within the mediation, and we could, make that successful. So it's not that all the mediators are, having that kind of feeling that we shouldn't have the advocates and we are the kings, as Rajesh sir told. So, but most of the mediators yet need to understand what mediation as a whole is and how they can go hand in hand with the advocates and the clients to reach an amicable settlement, which can even save relationships. Now, there was this another that was my third experience, and I think this was a partnership firm which was going into dissolution, and one of the partners was angry that the other partner had misappropriated funds. Now, my client being a lady, she was, anchored, she was anchored in her anger towards her partner, feeling that she's not going to get any justice through the mediation because she felt somehow the mediator was biased towards the other client, um, being a male mediator and the other partner being a male, so she felt like there's some bias there. But then I had to go ahead and explain to her that, see, this is mediation is a win-win situation, probably where you would get much more than going for a litigation, and you wouldn't get what you expected. So she agreed to sit through the mediation, but as Rajasthan told, sometimes it's the competition in the mind that's so angered that they want to make sure that the other party is like, called out, and they want to expose the party. So it is the mindset of the clients as well, which need, not most of the people, they understand what mediation is, because we have a tradition where everything goes to the court and they litigate it and one of them wins. So we need to, train our clients too on what mediation is. So this mediation awareness is very important, not only for the mediators, but for the advocates as well as the parties who come to the mediation. Yeah, so these were my three experiences that I could share here today. So yeah, mediation plays a big role, and today mediation is the word or is the happening thing. And courts advise to go for a mediation, but I feel like, there's more than the training. It's the checks and balances, as we call it. So whatever they are being trained on, maybe, there should be an awareness also parallelly running to it. Thank you.
Thank you for those comments. And perhaps we can move on to perhaps the heart of mediation advocacy, negotiation. Because we have seen that there are multiple roles a lawyer perform in mediation advocacy, starting from advising the client. But if you ask me, what is the heart of mediation advocacy? What's the biggest contribution a lawyer can make in a mediation? Is something which we are unfortunately not very familiar in a mediation setting. That is negotiation. We don't expect to be negotiators in a mediation settlement, probably for the same reason, because we have a conceptual deficit in understanding mediation the right way. So until and unless we understand mediation as facilitated negotiation, and negotiation is equally important or perhaps more important than facilitation, this role of lawyers won't come to the fore. But the fact is, it is the heart of mediation advocacy, and it is perhaps the biggest role a lawyer can play in mediation. Now, we know that we all know to negotiate. Negotiation is not unfamiliar to us lawyers. We negotiate settlements, we negotiate commercial arrangements, we negotiate contracts and countless other things that will never reach a courtroom. Much of the legal conventional negotiation is positional. When I say positional, it simply means that each party begins with a position. I make a claim, advances arguments in support of it. I'll argue for my claim, make some concessions in between, and ultimately hopes to arrive at an acceptable compromise, more acceptable to me than you. This is commonly described as positional or distributive bargaining. The underlying assumption is simple, that disputes involve a fixed amount of value, and success lies in securing as much of that value for our client. The exercise is about claiming as much value as possible. Fixed value, claim as much as you can, positional bargaining. There is definitely nothing inherently wrong with this approach. Many disputes are genuinely distributive, where the issue is simply how an existing entitlement should be divided. Positional bargaining may be entirely appropriate, and lawyers should continue to be proficient in it. We should know how to bargain in a positional way. But the difficulty arises, especially in the context of mediation, when only positional bargaining is something we know how to negotiate. Once we know only that form of negotiation, of positional bargaining, we may be in trouble, especially in the mediation context. Mediation actually invites lawyers to approach negotiation differently. Not always, but most of the time. Instead of beginning and ending with positions, it encourages them to look beneath those positions to the interest which usually underlies those positions. Positions basically tell us what the parties are asking for. And interests, the underlying interest, often explain why they are taking such positions. Once those underlying interests begin to emerge, new possibilities of settlement can become very apparent. And that's one of the reasons why integrative negotiation is attractive. And this requires a change the way lawyers think about negotiation. Instead of assuming that the available value is fixed, as in the case of positional bargaining, mediation encourages the parties to explore whether additional value can be created before how we decide to divide it. Different scholars describe it by various ways. Some call this shift is from distributive to integrative negotiation, from positional bargaining to principal negotiation, sometimes value claiming to value creation. Doesn't matter. Whatever be the terminology, the underlying idea is much the same. Before deciding how the value should be divided, before you split the pie, ask whether more value can be first created, whether we can expand the pie. In integrative negotiation, the lawyer is no longer concerned only with securing concessions from the other side, as in the case of positional bargaining, but also about identifying solutions that satisfy important interests on both sides, of course, without compromising the client's legitimate objectives. Integrative bargaining is not asking lawyers to retreat from advocacy, nor does it ask lawyers to be less committed to their clients and take the welfare of the other side into consideration. It simply recognizes that in appropriate cases, the clients may be better served by creating opportunities than merely contesting these positions. By taking a position, fighting over it may not always serve the client. Sometimes jointly generating options and finding solutions may be more suited in a situation. Now, creating additional value, integrative negotiation sounds great, and creating additional value before dividing it sounds great. But for that, the parties must be willing to share information, explain what really matters to them, explore possible solutions together. But doing so creates a kind of dilemma for negotiators. for lawyers. If you reveal too much, the client's bargaining position may be weakened. The other side may take advantage of it. If you reveal too little, then people don't understand each other and opportunities for settlement may never emerge. So if you reveal too much and if they go into positional bargaining, you are going to lose out because they are going to take advantage of all what you disclosed. If you reveal too little, you can't engage in integrative bargaining because we don't share enough information. Balancing these competing considerations is one of the most difficult aspects of negotiation. Is that so, Ruben? I know that you have a view on that. So perhaps you can share your experience about balancing these competing considerations, which is admittedly one of the most difficult aspects of negotiation.
Yes, yes. Good evening, everyone. I guess I'm audible.
You are.
So yeah. So yes, Rajesh sir very eloquently said how better integrate how rosy integrative mediations are, negotiations are. But then again, yeah, it is rightfully so. It is it's a very good concept or a thing to get into. But it comes with its own challenges. Any mediation, particularly regarding dispute, comes with its own challenges. So what we're seeing here is basically two opposite people. In most of the cases, high on emotions, takes up very personal, and one wrong word, then it goes everything down. So it can be a very tricky situation for the mediator, for everyone involved, be the mediator, be the party, or the advocate. So again, this tricky situation itself is the reason why advocates are very much needed in a mediation advocate. I mean, the process of mediation. As Rajesh sir already said, negotiation comes at the heart of mediation because that decides the entire direction in which the conversation goes, whether a settlement happens, whether it doesn't happen. So negotiation is the heart of the mediation. So coming to that, the most important thing in a negotiation is clear communication. The parties have to communicate clearly with the mediator because the mediator have to come up with not just the mediator, the parties themselves and the mediators have to come up with possible situations where reconciliation can occur. And this is exactly the place where the trouble occurs also because parties being high on emotions, they may not be in a proper position to express what exactly they want. There's a problem of what you say, lack of clarity. They may be overwhelmed. That's the one big issue. So particularly when it comes to court and its mediators and all, there are parties who still think that mediator is got the role of a judge. So whether this will affect my case or something. So they'll be in a it's an alien condition for them. So in that overwhelmness, it's the lawyer who has to make them familiarized with the entire mediation process. So that's the first place where the lawyer comes into the negotiation part. And again, as I already told, the clarity of communication, which is much needed for the mediation, which the party may not have given the situation which they are in. So this is the next thing where the lawyer can step up. You know your client's needs, you know his concerns, you know his problems, you know what he wants, and also you know the legal aspects covering it. The party may not be aware of it. The legal risk, you will have an idea that where the case might go into. If it's going to litigation, you will know, okay, 80% this will be going in our favor or the other guy's favor. So we got a better picture on how the legal aspects are also going in. So we are in a better position to negotiate on behalf of our parties. One is the clarity aspect. Second is that we got an overall view of the entire dispute. And also, it should be noted that as Sir told, integrative mediation. So again, we are as you already understood, integrative mediation is the kind of mediation which you already brings in more value into the basket, so that it can be distributed in such a way that both parties are not compromising. They are actually collaborating and getting more out of it. Again, from a traditional point of view, being two people at the law firms, it is difficult for them to come to such a situation. So being a lawyer who knows the concerns of the party as well as who can think objectively, you can help the assist your parties in getting in more options into the table, which can then be divided so that the value which gets divided is more than what the disputer already brought into. Now, this is again a tricky situation. You cannot just concede initially itself. You say, I am ready to do all these stuff, so you cannot do that. This has to be a a reciprocating process. You will offer what what you are offering one step at a time, and you wait for the other party's reply, whether he is willing to cooperate or whether he is trying to beat around the bush and somehow get away with the mediation. So you have to make a judgment in that regard. So you take a step, you look for the other party whether he's taking the step, and you find that he's collaborating, then you take the next step. So this is how it should go. So that is a strategy one has to adopt in an integrative mediation. See, there are two things. One is that there are two things which might seem contradictory. One is that you have to get the best out of the situation by getting people to contribute, making the people to open up, opposite party to open up, and also you couldn't expose your client's vulnerabilities. So, in order to satisfy or cater to this particular peculiar situation, we'll have to move one step at a time, wait for the other party to reveal what he is up to, and then it can organically develop into a collaborative process. So that's how integrative mediation takes place. And as already told, being a lawyer, we got in a much better position to get on with it compared to a client who is maybe emotionally charged or who is unfamiliar with the position. So that's my take on it.
Thank you, Ruben. Admittedly, it is one of the most difficult situations to be in. While we learn the theory of negotiation, we learn positional bargaining on one side and integrative bargaining on the other side. We don't fully realize from an academic level how difficult it is to choose which one is the most appropriate. So what mediation asks of lawyers is that difficult situation, is the kind of flexibility and judgment to move comfortably between different approaches of negotiation, to recognize when value must be created, when we should adopt integrative negotiation, when value can first be created, when we should be collaborating, or we use collaboration as problem-solving method. All of these are difficult situations, but once we become good negotiators, which we are supposed to be, we will be able to deal with it a lot more easily. Now, what we have seen so far, it's a kind of summary which I'm trying to, is that even though mediation has come a long way in terms of institutional development, in terms of recognition, it has not reached the real potential. It has not become an integral part of every lawyer's day-to-day legal practice. We argued that this suboptimal performance may be because we do not understand mediation well enough. Then we talked about mediation as facilitated negotiation and also the need for the emergence of mediation advocacy. We examined mediation advocacy in detail, tried to understand the various roles mediation advocate plays in a typical mediation with special focus on negotiation, which of course lies in at the heart of mediation advocacy. We saw the slides. We then identified that much of what mediation advocacy requires is already familiar to us, the lawyers. The analytical, the advisory, the counseling, the drafting, the courtroom advocacy skills, all of those we are familiar with. We found that mediation practice requires two additional competencies apart from our lawyering skills. One is a deeper understanding of mediation and understanding mediation as a distinct model of dispute resolution. We also need a more sophisticated approach to negotiation. So two things. We should understand mediation well. Two, we should master the art of negotiation. Moving forward, remember that There is no doubt that the emergence and development of mediation advocacy will benefit lawyers. It not only equips us to participate more effectively in mediation, but also enriches our broader legal practice through these additional competencies, through better understanding of mediation, through the mastery of negotiation. Yet, we see that mediation advocacy has received far less attention than it deserves. That may have been understandable when the priority was establishing mediation and developing mediators over the last 20 years. As mediation enters its next stage of development, however, I think our focus should be to include lawyers in the framework of mediation. We should make a deliberate attempt to get lawyers involved, train them to be mediation advocates, and get involved in the mediation. Now, I pause here to take in two views actually, one from Anirudh and next from Naureen. Naureen is a law student and we want to hear the law students' take on mediation advocacy. And before that, let's listen to Anirudh. Do you have any comments on how to take mediation advocacy to the next level, or any suggestion as to what should be the way forward? Anirudh.
Okay, so my perspective is threefold in this regard. So, moving forward, what should the future of mediation advocacy should look like? So, let me focus on the three very basic ideas. If stressed on, would make a huge difference. Is what I feel. The first one is training lawyers through the mediation process, not just after their enrollment, after they become advocates, but it should happen from the time they enter from the time they are students as well. So, issue is that most of us did not learn negotiation, mediation process, or any kind of interest-based problem solving during our LLB days. And more or less, we focused on sections, we focused on procedures, we focused on case law memorization, and we also focused on moot courts, which has, to a certain extent, helped us in understanding a real world situation. But insofar as how things work, it hasn't given us a full picture altogether. So, and further on, we've also come across statements like you'll pick up negotiation on the job, and that is what your job will be training you for. However, unfortunately, the scenario is completely different today, and many law firms or even law chambers as well, they expect negotiation to be a skill set that you carry. And further on, in Chennai, at least, if I have to say, the pre-institution mediation settlements have increased multifold solely because of the fact that many young advocates who've been taught negotiation and the art of mediation through law school have come and ensured that the matter has been settled. So likewise, I think if something similar happens all over the country, just not focusing alone on Chennai as well, I think will make a very huge difference. Is what my belief is. Now, if the second aspect is, sir, you had rightly pointed out, which is the money aspect, which is the economic credibility of mediation as a profession for advocates, for lawyers. So, one of the many reasons why lawyers hesitate to actively recommend mediation is an unspoken fear that maybe if the matter is settled early, means that your fee that should come to you would be far less than what it would have been if your matter had gone to litigation before the courts. So I think that does hold true to a very decent extent. And if mediation advocacy is to grow, I believe that we have to redesign the complete economic structure so that doing the right thing for the client does not also mean there is a financial sacrifice for the lawyer. So in that aspect, I think structure can be brought out. I think that must be left for later discussion because it is a topic in itself. Now, the third one is there is something that we as lawyers do, which is we hero worship people who go and stand before a judge and argue for hours together. And we, usually call them the gladiators of our profession. But that shouldn't be so, is what I feel. There should be a change within our professional culture. Mediation advocacy, invites us to expand that identity, not to. I mean, I wouldn't call mediation advocacy would mean that you have to abandon courtroom heroism, but also add another kind of a heroism to your portfolio, which is to be the lawyer, which is the lawyer as the architect of resolution, not only as an architect of battle. So when there is a change within our society itself, I think that would bring a huge, development for mediation advocacy to come into fore. So before I wound up, let's just go to a very small scenario. So imagine a future where there is a family business which faces a succession dispute. The default is not we'll file a partition suit, but let's see if mediation can produce a settlement that keeps the business going and would also make the siblings in constant touch with each other. So this in turn, if something like this is encouraged, this will also ensure that there is a harmonious society altogether, and that I think if we as professionals change our mindset would make a good difference in this aspect.
Thank you. Thank you, Anirudh. I thought you made some excellent points. One on need for training, two on having a need for economic rewiring of the reward system for mediators, and of course the cultural reset where gladiators are not limited to courtroom, but also the mediation room. Except that there may not be enough spectators because it's private and confidential. But of course, the news can spread. Now, Naureen, I'm sure you have. You may not have even encountered the idea of mediation advocacy before. Of course, you sat in our classes, mediation master classes. But what do you think of it as a law student?
So, good evening, everyone, actually. And I'm so happy and privileged to be here, a part of this experienced panel. So, as rightly mentioned by Sir, ഈ മീഡിയേഷൻ മാസ്റ്റർ ക്ലാസ് തുടങ്ങുന്നതിന് മുന്നേ അതുപോലെ തന്നെ മീഡിയേഷൻ സൊസൈറ്റിയുടെ ഒരു പാർട്ടാവുന്നതിന് മുന്നേ I didn't know what exactly a mediation advocacy was. And in my case, I believe most of the law students have no idea of what actually a mediation advocacy is. And I feel the main reason for that is our curriculum. We definitely have mediation as part of our LLB curriculum, but it is inside a subject called ADR. So ADR എന്ന് പറയുന്നത് actually ഒരു clinical paper ആണ്. So clinical papers usually ഈ core subjectന്റെ അത്രയും importance കിട്ടുന്നില്ല. ക്ലിനിക്കൽ സബ്ജക്ട്സ് നമ്മൾ എടുക്കുമ്പോഴത്തേക്കും മെയിൻലി കുറച്ച് ഇന്റർണൽ പഠിക്കുക, കുറച്ച് റോൾ പ്ലേ ഒക്കെ ചെയ്യുക, അപ്പോൾ നമുക്ക് ജയിച്ചു പോകും എന്നുള്ളൊരു കോൺസെപ്റ്റാണ് മൊത്തത്തിലുള്ളത്. അപ്പോൾ ഈ ADR എന്നുള്ള സബ്ജക്റ്റ് വരുമ്പോഴത്തേക്കും മെയിനായിട്ട് നമ്മൾ ചെയ്യുന്നത് ഈ റോൾ പ്ലേ തന്നെയാണ്. പിന്നെ ഈ റോൾ പ്ലേയിൽ വയ്ക്കുമ്പോഴത്തേക്കും പീപ്പിൾ വിൽ ബി ഡിവൈഡഡ് ഇൻ ടു ഡിഫറെൻറ്റ് ഗ്രൂപ്പ്സ്. ലൈക്ക് ഒരാൾക്ക് മീഡിയേഷൻ, ലൈക്ക് ഒരു ഗ്രൂപ്പിന് കൺസീലിയേഷൻ, ഒരു ഗ്രൂപ്പിന് ആർബിട്രേഷൻ ആൻഡ് ഒരു ഗ്രൂപ്പിന് നെഗോസിയേഷൻ, ഇങ്ങനെയാണ് യൂഷ്വലി കൊടുക്കാറ്. അപ്പോൾ ഈ സമയത്ത് വരുന്ന ഇഷ്യൂ എന്താണെന്ന് വെച്ചാൽ ഈ മീഡിയേഷൻ കിട്ടുന്ന ഗ്രൂപ്പിലുള്ള സ്റ്റുഡൻസ് മാത്രമാണ് മെയിനായിട്ട് മീഡിയേഷൻ ഫോക്കസ് ചെയ്ത് ക്ലാസ്സസ് നോക്കുക, അല്ലെങ്കിൽ ലെക്ചേഴ്സ് നോക്കുക, യൂട്യൂബ് വീഡിയോസ് കാണാം, ഇങ്ങനത്തെ കാര്യങ്ങൾ കാര്യങ്ങളൊക്കെ ചെയ്യാറുള്ളൂ. സോ എന്നിട്ട് ഇവർ ഈ വീഡിയോസും കാര്യങ്ങളൊക്കെ കണ്ടിട്ട് നമ്മൾ മെയിനായിട്ടൊരു സ്ക്രിപ്റ്റ് തയ്യാറാക്കും. ആൻഡ് ഈ സ്ക്രിപ്റ്റിൻ്റെ ബേസിസിൽ ഒരു റോൾ പ്ലേ ആണ് യൂഷ്വലി ഉണ്ടാവാറ്. സോ ദിസ് ഷോസ് ദാറ്റ് ഈ മീഡിയേഷൻ കിട്ടുന്ന സ്റ്റുഡൻസ് ആണ് കുറച്ചും കൂടി ഇതിലേക്ക് ഇൻപുട്ട് ഇടുന്നത്. സോ നമ്മളൊരു കാര്യം ചെയ്ത് പഠിക്കുന്നതും കണ്ടു പഠിക്കുന്നതും തമ്മിൽ നല്ല വ്യത്യാസമുണ്ട്. സോ ഈ ചെയ്യുന്നവർക്ക് മാത്രം ദേ വുഡ് ഹാവ് മച്ച് മോർ നോളജ് ദാൻ ദ പീപ്പിൾ ഹു ആക്ച്വലി സീസ് ദിസ്. ആൻഡ് ദ സെക്കൻഡ് ഇഷ്യൂ എനിക്ക് തോന്നിയതെന്ന് വെച്ചിട്ടുണ്ടെങ്കിൽ ഈവൻ ഫോർ ദ വൈവ, നമുക്ക് ADR വൈവ ഉണ്ടാവാറുണ്ട്. ഈ വൈവയ്ക്ക് പോലും ആർബിട്രേഷൻ ആൻഡ് കൺസീലിയേഷനാണ് കൂടുതൽ ഇമ്പോർട്ടൻസ് കൊടുക്കുക. ആൻഡ് മീഡിയേഷൻ ആൻഡ് നെഗോസിയേഷനൊക്കെ ആക്ച്വലി 1-2 ക്വസ്റ്റ്യൻ ചോദിച്ചാലായി എന്നുള്ളതാണ് ഇപ്പോഴത്തെ സ്ഥിതി. ഈ മീഡിയേഷൻ ആൻഡ് നെഗോസിയേഷൻ ആക്ച്വലി നമുക്ക് പ്രൊഫഷണൽ ടൂൾ കിറ്റിന് വേണ്ടി ഇമ്പോർട്ടൻ്റ് ആയിട്ടുള്ള സ്കിൽസ് ആണെന്നുള്ളത് ഈവൻ കോളേജ് തലത്തിലും കൺസിഡർ ചെയ്യുന്നില്ല എന്നുള്ളത് ഒരു ഇഷ്യൂ ആണ്. പിന്നെ നേരത്തെ പറഞ്ഞ പോലെ ഈ ADR അല്ലെങ്കിൽ മീഡിയേഷനൊക്കെ നമ്മുടെ കരിക്കുലത്തിലേക്ക് വന്നിട്ട് മേ ബി ഒരു 10 years 15 years മാക്സിമം ആയിട്ടുണ്ടാവുള്ളൂ. സോ ഈ സീനിയർ ആയിട്ടുള്ള ഫാക്കൽറ്റീസിന് നമുക്ക് മീഡിയേഷൻ പഠിപ്പിച്ചു തരാൻ വേണ്ടി ആക്ച്വലി ഇവർ ആദ്യം പഠിക്കേണ്ട വരുന്ന ഒരു അവസ്ഥയാണ്. ഫാക്കൽറ്റീസിന് വരെ അതിൻ്റെ ആക്ച്വലി ഉള്ള ട്രെയിനിങ് കിട്ടുന്നില്ല. ബട്ട് ദർ ആർ എക്സെപ്ഷൻ. ഇപ്പം നമ്മുടെ കോളേജിൽ പറയുമ്പോഴത്തേക്കും വി ഹാവ് PS ആൻ്റണി സർ. ഹി ഈസ് ആക്ച്വലി an accredited mediator and actively working for നമ്മുടെ കേരള സ്റ്റേറ്റ് മീഡിയേഷൻ കൗൺസിൽ ആൻഡ് ഓൾ. സോ അത് എക്സെപ്ഷൻ ആയിട്ട് ഇപ്പോഴും നിൽക്കുകയാണ്. 1 or 2 നമുക്ക് വിരൽ ഉണ്ടാവുന്നവരുണ്ടാവുള്ളൂ ഇതുപോലെ ട്രെയിനിങ് കിട്ടിയതിന് ശേഷം വന്ന് പഠിപ്പിക്കുന്നത്. ബട്ട് ഈവൻ സെറ്റ് ദാറ്റ് സോ നമുക്ക് മീഡിയേഷൻ ആക്ട് 2023 വന്നതിന് ശേഷം കുറേയും കൂടി നമുക്ക് മീഡിയേഷൻ ഇമ്പോർട്ടൻസ് കൊടുക്കുന്നുണ്ട് കോളേജസിലാണെന്നുണ്ടെങ്കിലും. ടീച്ചേഴ്സ് ആർ ട്രൈങ് ടു ഗെറ്റ് us അപ്ഡേറ്റഡ് ഓൺ വാട്ട് മീഡിയേഷൻ ഇസ്, അല്ലെങ്കിൽ മീഡിയേഷൻ ആക്ടിൽ പറയുന്ന കോർ ഫീച്ചേഴ്സ് എന്താണ്. ഇപ്പം ഇൻസ്റ്റിറ്റ്യൂഷണൽ മീഡിയേഷൻ ആവട്ടെ, പ്രീ ലിറ്റിഗേഷൻ മീഡിയേഷൻ എന്നുള്ള കോൺസെപ്റ്റ് ആവട്ടെ, ഇതൊക്കെ കുറേ കൂടി ഇൻട്രൊഡ്യൂസ് ചെയ്യാൻ വേണ്ടി നോക്കുന്നുണ്ട്. പക്ഷേ ഇപ്പോഴത്തെ ഒരു ടൈം എന്ന് പറയുന്നത് കോർട്സ് ആണെന്നുണ്ടെങ്കിലും ലെജിസ്ലേഷൻ ആണെന്നുണ്ടെങ്കിലും മീഡിയേഷനെ പ്രൊമോട്ട് ചെയ്യണം, മീഡിയേഷന് വേണ്ടി അഡ്വക്കേറ്റ് ചെയ്യാണ്. സോ ഐ ബിലീവ് ദിസ് ഇസ് ആക്ച്വലി ലൈക്ക് ദ റൈറ്റ് ടൈം ടു ഗിവ് മോർ ഇമ്പോർട്ടൻസ് ടു മീഡിയേഷൻ ഇൻ ദ കരിക്കുലംസ്, because we are the lawyers of the future. So we should know, we should have the knowledge, and we should be able to know what mediation is to go for these opportunities that are in front of us. So I believe this is a high time that mediation is given the importance that it deserves. Thank you.
Thank you. I hope you did not alienate too much of your faculty members by saying what you said. But at least Anthony sir will be with you. Now, this is something which we have noticed, the lack of training, not so much on mediation. Mediation, people are training in mediation. There are courses available for mediation. But when it comes to mediation advocacy, less and less people, we realize that less and less people have heard about it. Although, as I mentioned before, half of the competencies you already have. You just need to polish your additional competencies and just make sure that you know what mediation advocacy is, and you can simply add strategically that into your toolkit as a lawyer. So recognizing that, I think this is an opportune moment to make an announcement on behalf of the Mediation Society that from our next mediation masterclass, that would be our 7th edition in this year, we will have a special focus on mediation advocacy, so that more and more people understand and take up mediation advocacy. And that's the only way forward for mediation advocacy, lawyers, and for mediation itself. And after all, we practice what we preach. Now, in conclusion, this is what I want to say. If the first 20 years of mediation in India were devoted to building the process and developing mediators, perhaps the next 20 years should focus on developing mediation advocates. This is not about giving less attention to mediation or to mediators, but about giving equal attention to mediation advocates. Only then will mediation become an integral part of the lawyer's everyday professional practice. Only then will mediation realize its full potential in India. Thank you.
Thank you, speakers. I know that we are running short of time, but we do have a couple of questions in the chat box. So can we quickly address some of the questions? So one question that is posed to us is specifically asking about negotiation and mediation skills. How can young advocates acquire such skills since it is not covered in our LLB syllabus? Should they attend mediation class?
I love these self-serving questions as far as mediation society is concerned. One of the things, as Noreen pointed out, is colleges are picking up, law schools are picking up on ADR, law schools are picking up on mediation. Law schools are increasingly realize that Conciliation Act is almost as good as gone, and we should have a Mediation Act soon, and that there is no difference between the idea of conciliation and mediation. All of these mediation law schools are picking up. So I foresee changes in the legal education, formal legal education in the LLB curriculum in the coming years, where they will focus a lot more on mediation than they are doing now. So that's one thing. Of course, there are courses which people like us and other private bodies run as part of their mission to promote mediation, like mediation masterclasses. Not all of you could possibly attend those, but if you try hard enough, you will be able to get into one of the courses. So that is another way of acquiring the skills. And the other thing, as I said, while mediation masterclasses or courses on mediation, specific courses on mediation is important, all you have to do, if you can't get into any of those courses, is to make sure that you become a good lawyer. If you become a good lawyer, if you develop the right skills as a lawyer, half the work or most of the work is done. All you need, it's a very simple step forward to become a mediation advocate. You become a better advocate, you become a skilled advocate, and becoming a mediation advocate becomes so much easier. So, you don't have an excuse. Even if you don't have access to any of the specialized courses, you still can try to become a good lawyer, acquire all the skills which a good lawyer need to possess, and then at the first opportunity, jump into a specialized course where you can develop a deeper understanding of mediation and polish your skills on negotiation. So that should be the way to deal with it, I think, unless any of the speakers have something to add.
Yes, I think we can take up one more question as one final question. Taking a cue from what Anirudh just mentioned about courtroom heroism and taking the question that is put, how can lawyers better balance their duty to zealously represent their clients while encouraging a meaningful settlement in mediation?
I think that question assumes that these two are different things, to think that zealously representing your client is not equivalent to getting a great settlement for them is probably where we are making a mistake. How do you zealously support a client? Get them the best possible solution. Get them the best possible solution in the best possible way, probably the most efficient way, probably the cheapest way. That is how you defend or represent your client better. So they are not binaries on the two extremes. They are the same thing. When you represent a client in a mediation and get them a great settlement, that is how you represent a client in the best possible way. But I see the flip side of it is sometimes our conditioning, seeing the gladiators in the courtroom, what we are used to, conditioning think that courtroom advocacy where you fight with the other person, you quarrel, you compete, you win on the basis of legal rights is basically what lawyering is all about. That is conditioning. I mean, I'm sure that you have seen enough courtroom dramas on the net, as it involves negotiation as well. So it's not just that the courtroom advocacy is dramatized and hyped up in the TV serials, although they are more in number. We also see a lot of negotiations which are equally glamorous. So I think the point is we should see it not from a perspective of our conditioning. We should not allow our conditioning to guide us into the future. As a lawyer, you should be looking at your client's best interest. It's not saying that mediation is the best option always. Negotiation into collaborative problem solving is the best way forward always. It may not be. If need be, you should be able to defend them in a court of law, argue on the legal rights, and fight on legal responsibilities. That's all fine, except that in appropriate cases, as a lawyer, the smartness, the seamless representation lies in the fact that we will be able to pick up the right, most appropriate dispute resolution process for the client and perform what that process requires, if it's negotiating, if it's mediating, if it's courtroom advocacy, whatever it is. So that is where probably we should be going.
Thank you. Thank you so much. As we conclude this two-part series, I extend my sincere gratitude to all our panelists and all the participants who joined us over the last two sessions. We hope these conversations have demonstrated that mediation advocacy is not about replacing litigation, but it is about strengthening legal practice. As we have already conveyed, our team, the Mediation Society, is keen on organizing more programs like this. So to stay connected with us, please do join our WhatsApp group. The link is once again shared.